Welcome to Workers' Comp Know Your Rights.
Hi everyone, I'm Tracy Merda. Today I am joined by experienced attorney Kathleen Dotoli, whose practice focuses on workers' compensation and Social Security disability law. Today we're going to learn the ins and outs of workers' compensation law in New Jersey. Kathy, thank you so much for joining me today.
Hey, Tracy.
Well, I want to just dive right into talking today about the disputes of what to do when your claim is denied.
Well, sometimes what I need to do is after I file that claim petition, the claim petition in the Division of Workers' Compensation, remember, not a lawsuit, but a claim petition, I will file that, and then I will have an opportunity to talk about that claim with someone from the workers' compensation carrier. Now, if we can't come to an agreement on whether that individual is entitled to medical benefits, wage replacement, or something else, then it's time for the motion for med in temp. Now, what is a motion for med in temp? Well, it's something that I file with the Division of Workers' Compensation Court, usually supported by medical evidence and a certification from my client explaining, outlining exactly what happened, how the accident happened, whether there were any witnesses, who they told, what was the injury, have they been to doctors, and the relief sought at the Division of Workers' Compensation. And if there's medical documentation that backs that up, and there usually is, my doctors, either perhaps a treating doctor who's recommending treatment, who's recommending diagnostic studies, injections, or something else, will back up, what it is that I'm asking for. And guess what that does? That gives me an opportunity to talk over what my client's situation is with a judge of workers' compensation with the respondent. And then we sort out what these issues are. Now, Tracy, it could be a causation problem that's holding the claim back from moving to the next level for treatment and whatnot. It could be a notice problem. Maybe the claim wasn't, the individual, the injured worker didn't give correct notice, or maybe the notice wasn't then conveyed to the workers' compensation carrier in a timely manner. I mean, it really could be anything. But that's what gives me the opportunity to get before a judge and hopefully get the information, get the medical treatment, get the wage replacement that my client, I believe, is entitled to at the time of the filing of the motion. Now, my client might have to come in for testimony. My client might have to come and explain everything that was in that certification. Sometimes the respondent, the people who work for the employer perhaps, maybe they're going to come in and they're going to say, wait a second, that's not how we understand it. We think that this happened instead. And then after the testimony, the judge makes a determination. That happens, quite frequently in workers' compensation court. In every vicinage in the state, they have motions for med in temp listed every day. And, we keep our judges very busy, and they're essential to making sure that, we get these cases resolved in a fair and equitable manner.
Kathy, what are the common reasons or these excuses that insurance companies are using to deny or limit these claims?
Well, somebody who comes in with a back injury, per se, let's take that example. Someone comes in with a back injury, but maybe the insurance company is reading it like this, or maybe a doctor is reading it like this, that maybe that person has an extensive pre-existing history of back problems. Maybe they had a back surgery 5 or 10 years ago. Maybe they had diagnostic studies that showed herniations or osteophytes in the spine. What we need to do then is bring that injury, up to the present day and say, how does this injury feel now? How does your spine feel now versus how it felt prior to this incident? And then we also maybe want to look at diagnostic studies and compare the two and try to determine, is it a condition that did get worse as a result of a lifting injury, a pushing, pulling, any kind of injury involving the neck or spine. So that's what we do.
I'm curious what the role of the insurance adjuster actually is in these processes or these cases.
Yeah, there are a lot of really excellent insurance adjusters out there that, are working with injured workers to make sure that they get the diagnostic studies they need, that they get the surgeries needed, they get their medical appointments followed up with, physical therapy, injections, depending on the injury. But yes, the insurance adjuster is an essential player in navigating through the workers' compensation system.
Now, what about that relationship between the employer and the insurance adjuster? I think that's sort of a gray area, if you will, for me anyway, when trying to get a handle on these cases.
When an insurance claim, a workers' comp claim, is initially reported, ideally, especially if there's, maybe a gray area, but I think, I don't work for an insurance company. I only work for injured workers. But I think ideally you want some level of investigation to take place on every claim that comes in. A lot of missteps can be corrected very, very, very early on if a proper investigation is done by the carrier, calling to find out, were there witnesses, or, what did the individual say about the claim? Did you follow up with an accident report? And encouraging those employers to have a system in place when a worker is injured.
So what internal guidelines or criteria do insurance adjusters follow when they're deciding to deny or approve a claim?
Well, they may have a conversation with an individual, the injured worker, maybe before they are represented by counsel, where an individual might lead them to believe that they had a preexisting condition. And, if you're stating that you have a preexisting condition and that, let's use the back injury again as an example, that back has been bothering you and you've had diagnostic studies and maybe even some treatment leading up to that work accident, the insurance adjuster may look at that claim and say, well, this person had a bad back going into the claim. But again, hiring an attorney like me, I would get to the bottom of whether or not this situation exacerbated, aggravated, worsened that pre-existing back injury. And if so, we go forward.
So how do insurance companies typically respond to an appeal? What role does the negotiation play in this part of the process?
So it's not really an appeal. What it is maybe a more thorough investigation, bringing more information to light, getting the medical records from years ago, getting the diagnostic studies from years ago, getting newer workups, new diagnostic studies, and perhaps being able to show that a condition was made worse by a more recent accident.
So what are the most effective strategies that you use for appealing or responding to a denied claim?
Well, information, documentation. I want to really get in there with my client and try to figure out where did this claim go awry? Because really most claims are accepted. If you have a traumatic event at work, slip and fall, you had a lifting event, you can identify the place, the time, how it happened. Those claims are more frequently accepted than not accepted. So, but how do we get into it? We go through the medical history. I do that usually on the very first time I'm talking to someone, by the way. I will always ask somebody, did you have a pre-existing condition? Did you have any prior workers' comp claims? Did you have a motor vehicle accident or a slip and fall? Did something happen to you? Did you have a sports injury when you were in high school? Has anything been bothering you pertaining to your injury prior to this event taking place? So I'd like to know more information going into the claim. Before I start to really work on it and prosecute that claim, I want to know as much as I can about that individual.
I would like to know more about how maybe having your firm on board made all the difference in the outcome of a disputed claim. Do you have any favorite stories that you can share with me?
Well, the notice thing is really big. This is not the first time I'm talking about notice. A lot of my social media will address this notice situation, because when an individual gets hurt at work and the notice isn't there, or it's improper notice, or you told somebody and they didn't do anything with that information, that's like infuriating to me, because that's a failure on the part of the human resources department or the manager of the company, or somebody who's in charge of taking this information down. And it's disheartening, because then somebody, they go home and they can't work, and maybe their hours are cut as a result, and they say, do I do anything with this? Do I go to a doctor? And now maybe their insurance is cut, and they can't pay the COBRA, and they're without any medical treatment at all. That's very disheartening and disappointing to me, because I know that proper reporting of an injury when it first happens starts with a conversation, usually between the employer and somebody at the employee and somebody at the employer's facility, whether that's human resources, a manager, or something else. So with that communication, the treatment starts, the evaluations start. Without that proper notification, not much happens.
One of the things that I've loved since the moment really of meeting you was you can really feel your passion and your fight. Give me some reasons, or tell me a little bit about what that experience looks like when someone hires your firm on to represent them in a workers' compensation claim.
People are very confused when they come in with a workers' comp claim for the very first time. I mean, people who are in very laborious jobs, very oftentimes, it may not be their first claim with me. There are people who work in laborious jobs where I've represented them on and off on different claims, different body parts for 10 years, 20 years. And we resolve those claims, periodically. And then unfortunately, maybe something else happens. But for the individual who has an injury and comes into us and wants to know more, it's extremely gratifying to tell them all of the rights and benefits that are available to them, such as fully paid medical, no copays, no deductibles. They are entitled to wage replacement if an authorized doctor says they can't work. They don't have to file for unemployment or state temporary disability. If this is an admitted claim, and from the very, early days of the claim, a doctor says they can't work, that's what they're entitled to. And I think it comes as a great relief to them that they're going to be taken care of in terms of their wage replacement and their medical. I also know that they're very oftentimes happy to find out that because of their limitations as a result of that injury, compensation may be due at the end of the case that addresses their loss of function. And I'll tell you another really important benefit here, Tracy, is that if they settle a case on what's known as an order approving settlement, they can reopen that case. They can reopen the case as long as they do so within 2 years of receiving their last check, the date on their last check. And they can reopen the case and seek additional medical treatment, additional wage replacement. And if the condition got worse, they may be entitled to an additional settlement at the end. So That's a very, very important benefit, and that can extend the life of the medical component of the claim. So really, really important to keep that in mind.
Well, that sounds like a whole nother episode right there. So I just want to thank our listeners, and thank you, Kathy, for joining me today on all things workers' compensation law in New Jersey with attorney Kathleen Dotoli. For more information or to connect with Kathy direct, go to lawofficeofkathleenmdotoli.com. Be sure to hit that like and subscribe button and leave us a review in the comments.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.